call Prof. Bonita Meyersfeld. She'll be leading one of our witnesses this morning on Kredietbank's legal liability.
Good morning.
Good morning.
Would you kindly state your full name so the record?
Bonita Meyersfeld.
That's it. Professor Meyersfeld, it was testified yesterday that, so as I kept saying throughout the day yesterday, that the thesis of this particular section of the tribunal is that the United Nations imposed embargoes prohibiting trade or encouraging or in any way participating in providing access for South Africa to weapons. And this embargo was circumvented in various ways. There were different actors, private and non-private, i.e. countries that quite frankly aided South Africa in gaining access to weapons during the period of the embargo. And some of the countries made mention of was France and Germany, arguably Belgium. And there were private actors that contributed in the circumvention of the embargoes. And one of the private actors that was quite frankly a leading actor was the Kredietbank. Kredietbank helped South Africa in two ways. It helped South Africa's arms corps. I'm assuming you're familiar with arms corps. It helped the arms corps in two ways. One of the ways was that it assisted in the creation of sham companies, shell companies. And the other was that it facilitated in creating or providing access to bank accounts. And it was through these banking accounts and banking channels that money was transferred from Pretoria through different dark channels to the ultimate recipient of the money, or as Mr. Van Vieren said yesterday, assembled in Luxembourg. So the role of Kredietbank is quite identifiable in the circumvention of the embargo. And what you are here to speak to really is A, whether Kredietbank could be held liable, and B, how so. But before we proceed to your actual presentation, I wonder whether you're able to tell us a bit about your background, which places you in good stead to speak to this topic.
Let me begin by saying thank you for this opportunity to participate in what is both historic and seminal tribunal, and thank you to the members, and I look forward to engaging with you. To answer your question, your first question, Advocate Mavangwa, I am an associate professor, an academic, but I've also, until the end of last year, been the director of the Center for Applied Legal Studies at Wits Law School. The bulk of my experience has focused on international and national human rights law, and that is addressing power or repositories of power that include not only the state, but also private actors and specifically corporations. In that regard, I have done a great deal of work, both nationally and internationally, around corporate accountability for human rights violations, and specifically focusing on the accountability of financial institutions. So financial institutions remain one of the most hidden and silent actors in the perpetration of human rights violations. They're the agents at the heart of this activity. They're the agents without whom our economy could not, would not operate. And yet they are the agents that have been not only untouched and not only invisibilized, but when they have indeed been identified as agents of harm and corruption, have escaped all accountability and liability, as we saw in 2008 financial crisis in the United States. And that has been the focus of my work, both as an academic and activist, but also as a teacher.
Thank you. So the first question I have, you're a professor, you can take an overload of questions in one go, I'm sure. So my first question to you, Professor Meyersfeld, is what are the possible options for holding Kredietbank to account for its role in assisting Arms Corps during the embargo? So that's the actual question. But as you answer the question, though, if you don't mind, it would be good if you could also, in addition, bear in mind the fact that the embargo on weapons to South Africa was a particular response to how the weapons were being used by the South African apartheid state. The weapons were being used to repress as well as to murder, quite frankly, people. So that's something I would like to keep at the back of your mind. So of course apartheid was also declared a crime against humanity by different conventions that I need not catalog for you.
Sure, and maybe I can briefly outline, I think, the discussion that was held yesterday and the evidence from Mr. Van Vuren to understand the role of a bank, which we don't often consider as a role player when it comes to crimes against humanity, and certainly not during apartheid. What I would like to do is not only, however, focus on what happened during apartheid and sanctions busting, but to link it to the kind of problems we're facing today vis-a-vis banks, not only in our country, but internationally. So let me begin with the story. In the late 1970s to the mid-1980s, as Advocate Muvangwa has pointed out, there was a comprehensive and increasingly tight set of regulations internationally preventing and prohibiting any association with the South African government in respect of the trade and development and maintenance of arms and weapons. This, of course, was in many ways a fallacy. We know that South Africa's arsenal was developed and in fact became one of the strongest internationally during an international embargo. There were states that were open about this participation, Israel being one of them, but there were also states that simultaneously to depositing their letters of confirmation with the Secretary General of the United Nations in support of the embargo were actively participating in the breach of that embargo. This is the evidence that we've obtained from the research done by Mr. Van Vuren, but also information that is available out there in different fora. How did this look? Very simply, the governments of countries such as Belgium, France, Portugal, were able to utilize private entities to enter into engagements with banks that would very elegantly set up shelf companies. What are shelf companies? Shelf companies are companies that are institutionally set up but have no real purpose, have no real structure. So the company would be set up and you would have dozens, if not hundreds, of these companies set up across the world, where a corporate actor in the global north, say in Belgium, would take funds, channel them through these front companies or shelf companies, which would ultimately land up in South Africa with money that would then go to Arms Corps. Arms Corps would then have that money and sell on arms, and the reverse was also true. Those shelf companies were utilized in a way that would allow the South African government to channel funds back into the countries I've just identified, who would then on-sell arms and also arms components. And I think it's important to recognize this. We're not only talking about a cachet of AK-47s, this image inculcated by the Lord of War movies. They're also parts of machine guns, but also parts of helicopters, parts that were used to maintain weapons that were then agents and facilitators of the crime against humanity of apartheid. So this series of shelf companies allowed for transactions that almost like a spy novel occurred in the back rooms of the very embassies of the countries that were standing against apartheid. They used the same official handbags that you would use as an ambassador to go to the government of the country in which you were located to hand over formal state information. The collapse, in other words, between the corporate entities seeking to bust sanctions and the very governments openly supporting the embargo is clear. And it is that type of complicity which frankly goes beyond complicity. It is that type of fundamental participation in the busting of the arms embargo that really has come to light and that needs to be interrogated at various levels. And that, I hope, answers your first question, Advocate Muvangwa. And I can go on to how that accountability could look if that's what you'd like me to do, or wait for another question.
So what I would like to briefly outline for us, though, is the possible options that we have in holding these banks accountable. If we do have such options, which I desperately hope you're going to say we do.
About 2 years ago, perhaps even longer, when I met Mr. Van Vuren for the first time, this question was posed around if there is a clear act, a clear crime committed by an actor that is not a state actor, is there any way in which we can hold that actor accountable for their criminal conduct? To my mind, my immediate response was, well, there has to be a regulatory body, a banking authority to which we can lodge a complaint. And I undertook to go away and develop a number of possible ways in which we could seek accountability and through which we could seek accountability. And the journey was both an interesting one intellectually, but a devastating one on an ideological basis, because the reality is that there is no international entity, cross-border entity, that can hold or does hold banks to account for their compliance or for their non-compliance with standards around international banking, and more importantly for the participation in the funneling of funds that emanate from criminal activity. This was not the case in the 1980s, but devastatingly this is not the case today. There is no one single body or authority in an international or national context to which one can make a complaint as a victim of a violation committed by a bank to hold that bank accountable. Let me be clear about this. There's no judge, there's no body, there's no entity, there's no regulatory authority, there is no one holding banks to account. There are loose principles, but they're entirely voluntary. There are notions, there are the Basel principles, there are, of course, a number of voluntary mechanisms or international principles to which you can sign up, and generally there is an astounding lack of compliance with those actual principles. So we're left in an accountability vacuum. But before I make you very grumpy and unhappy at the idea of there being no form of accountability, let me be clear about the options that I think are available. The first is something called the OECD National Contact Point. The OECD is an organization, the Organization for Economic and Cooperation and Development. My apologies, thank you. And the OECD is a collection of countries generally with a large economic income, with a large and sophisticated economic basis, and generally they hail from the global north. One of the unique components of the OECD is its regulations around multinational corporations, and it has a body of content that speaks to issues such as corruption, environmental considerations, and also, of late, human rights standards. So it specifically speaks to states, and it says to states, you have an obligation to ensure that the corporations that are registered in your country, that are based in your country, do not engage in activity that would be a violation of international human rights standards, and certainly in violation of the standards of the national country. You have an obligation to make sure that that doesn't happen. And if that does happen, then we've set up a type of quasi-adjudicatory body called a national contact point, located in each member of the OECD, and that body can hear complaints from individuals. So how would that work in the scenario we've just described? Well, Kredietbank is an entity that, as we've already established, facilitated the busting of the arms sanction during apartheid. That arms sanction led to the development, the maintenance, and the accumulation of weaponry that was directly responsible for the horrifying oppression that occurred of dissidents and of black people during apartheid. We all know the imagery. In other words, there is a direct causal link between the activity of the bank and the young boy murdered in an attack on the township. There is a clear link. Proving that link, of course, is the difficulty. How do you prove that there was a particular transaction that led to a particular purchase of a particular mechanism that was used in a particular ambush at a particular moment that actually caused the death of that particular person? The importance of the OECD national contact points and their concomitant guidelines is that you don't have to prove that. You have to show that there's been a contravention of international human rights standards, that the company in question was liable for that, to evidence, to show in the way that we've been discussing here how that occurred. And then there's the possibility of two things happening. The one is that you can enter into a mediation with that company as the complainant, which has its advantages and its disadvantages. The second is you can actually propel forward a conversation about this accountability with the hope that the national contact point in question will ultimately provide a statement of accountability, a statement that will be public. And that statement could contain in it the following components. One, what standards were breached. Two, what behavior breached those standards, caused the breach of those standards. And three, what kind of compensation or accountability should vest on the part of both the company in question and on behalf of the complainants. Now, the importance of this is not because there has ever been meaningful accountability on the part of a company. What we've seen in the utilization of this mechanism is in a vacuum, in a desert of accountability for cross-border, multinational, transnational corporations. In a no man's land of accountability, there is one lone ranger. There is one lone entity that provides some semblance of accountability, albeit through a very public mechanism. And I say that there hasn't resulted in accountability, but it has had consequences. So we've seen cases, for example, against companies operating in the DRC during the height of the conflicts there around diamond mining, extraction, and transacting. And those companies, some of which have violated international standards around engaging with diamonds in the DRC, have in fact closed down their operations there, right? Are no longer companies with whom good citizens of the corporate world want to do business. So it's not your traditional judge who will deliver a judgment which will then have physical and economic consequences for the company in question. But it is a mechanism to which we can hold a proverbial spotlight on the conduct that was being done. And the reason why this is so important, in my view, is because part of going to something like an OECD national contact point and telling them the story is to evidence not only the violations committed by Kredietbank in the past, but also the complete impunity of the present. The fact that there is no single regulatory body to whom we could turn and say, banks have not only been complicit in human rights violations, but they have accumulated untold wealth as a result of that. And that wealth has become normalized. That activity on the part of banks has become normalized. And the violations, the burden that continues to be on the part of the most indigent and often black people in the world, that burden has not been shifted. And that's something that fundamentally has to change.
I just want to consolidate what you said before I put the next question to you. So apart from the OECD, your narrative is that there is effectively nothing we can turn to. Is that correct?
As individuals, so the South African government has some options. The South African government could arguably turn to a forum such as the International Court of Justice and ask for a convening before that tribunal of a state that housed and allowed for this kind of atrocity to occur. So, for example, it could request a hearing before the International Court of Justice with a country like Belgium or France, Portugal, or any of the countries that have been found through the evidence to have had a hand in sanctions busting, and have that court deliberate. But that, as anything with international law and international relations, requires political appetite. And when the Kulimani case first began, corporate South Africa reared its head in horror and said, why is it that we are going down this route? Because we will lose investment from international and foreign states. And the sad part is there's truth to that. There is truth that the moment you have accountability for corporates involved in violations, this counter-narrative of, yes, but you're going to lose investment, comes to the fore. And what we need from a political body and from a governing body is to say, well, we're going to first take steps to ensure that that accountability is not lost in the sea of search for new investment. To have faith in the governments of these countries that say openly they do not support apartheid, be it in the past or the current manifestation, and to ask them to take steps against the banks that have made this kind of money out of apartheid. So there may be other fora, and I named just one of them, but they're fora that are very unlikely to be used. And we have to, I think, question our government, both in its current form, but also in previous forms, as to why that type of international activity has not taken place. And I think there's a deep sadness and a deep regret that that has not occurred.
I want us to come back to the middle a little bit. The middle being the purpose of the sanctions in the first place. Now, we agreed, I hope, earlier, that apartheid was declared a crime against humanity, and when Kredietbank was involving in its conduct, circumvent or bust the sanctions, it was acting in direct contravention and essentially aiding a crime against humanity. You might have better understanding of this space than I do, but is there a way we could use the conventions at the United Nations to hold a private actor liable for having contravened a crime, having participated in the orchestration of this crime of apartheid?
Advocate Muvangwa, I have such deep respect for you that I don't want to make you unhappy, but I'm afraid that I must answer in the negative. There is no international entity that can hold a company accountable. Of course, there is an international entity in the form of the International Criminal Court that can hold individuals accountable. Typically, though, the individual accountability at the International Criminal Court speaks to state agents. Not always. There have been investigations into private actors, but you're looking at state agents in the context of of a conflict who have contributed or committed one of the crimes that fall within the jurisdiction of the International Criminal Court. Those crimes are genocide, crimes against humanity, war crimes, and the potential of aggression, the crime of aggression. And while, yes, apartheid, I think, indisputably is a crime against humanity and certainly is included as such within the International Criminal Court's founding statute, the Rome Statute, it is unlikely that there will be a potential to bring that case, such a case, to the International Criminal Court, if not impossible, because the International Criminal Court's jurisdiction only vests from 2002 onwards, and of course the activity in question occurred long before that. And I speak on this matter with some hesitation, given Member Pilay's role as a judge on that court, and who could certainly, I'm sure, interrogate that issue further. I should say, though, that the idea of holding corporates accountable in international law is very much at the forefront of a discussion at the United Nations, with the notion of a treaty actually being discussed internationally to hold corporations accountable for human rights violations. But the dynamic around those treaty discussions itself is informative. So the situation at the moment is that there are no binding principles governing corporate accountability vis-a-vis human rights violations. There are guidelines, and they are terrific guidelines, but they are not binding guidelines. They are guidelines ultimately that speak to the ideal that a state will hold corporations accountable and not international bodies. But we know the problem. We've just discussed it. The problem is, if you have a state that is economically crippled, if you have a state that is desperate for financial investment, that state is not going to turn around and simultaneously hold a corporation to account for its activities in violating human rights in that country. Very rarely, in fact, especially when that state, when that company has its home embedded in a state in the global north. And we see this classic example of, say, a country in the global north like the United Kingdom housing a corporation that seeks to do business potentially legitimately in a country like the DRC, which is beset with violence and conflict and beset with poverty. And there's this notion that the only way we can escape poverty is to actually have corporate activity operate in that country, which we call the host country, such as the DRC. And even if the host state, such as the government of the DRC, was invested in holding a corporation to account, even if we had that political will, how then do we prove it? How do we prove that a company in the United Kingdom knew about the conduct that occurred in a country like the DRC by one of its subsidiaries? So we run into all sorts of problems around corporate identity, the corporate veil. But the problem is we don't even have often that political will to do it. And that's why there's been a move internationally to ask for international binding standards that could create a tribunal of sorts that could hold a company accountable, which is interesting because a company is a fiction. But then again, so is a state. So we should be participating in that international discussion. And what's happened there is a little bit of a tug of war between, wait for it, the global north and the global south, between developed economies and developing economies. And it was only 2 years ago that South Africa and Ecuador came to the Human Rights Council of the United Nations with a resolution. And the resolution was to talk about a treaty, a binding treaty on business and human rights. And looking at the voting around that resolution and looking at the participation of states since around the discussions of that treaty, we see a clear divide between states that want to protect their capital and states that want to protect themselves and their people. And that's the dialogue at the moment. And it's a dialogue that's a very difficult one because it is a David and Goliath. We're seeing a lot of economically weak countries trying very hard to establish some kind of international tribunal to hold corporations accountable for their commission in human rights across borders. And yet at the same time, having a very real, strong counter-response from the countries on whom they're relying for foreign investment. It's a very delicate, very problematic situation. And that's why something like an OECD NCP, a National Contact Point complaint, can help reveal this gap, can help show that we're living in a time in which the government is no longer the sole agent of harm. The government official is no longer the sole agent of harm. It's the corporate agent that is often the co-perpetrator of harm. And they may not be holding the shotgun, but they are funding that shotgun. And they may not be digging the mine and holding a gun to the mine worker to extract sufficient materials to be sourced and transacted and ultimately become part of our engagement rings. But they are the ones providing the funds to do that. Or they are the ones who are participating with an oppressive government in capturing data of dissidents through electronic mediums. They are the ones who are harnessing data of individuals to ensure that they are able to make financial profits of the poorest people, certainly within this country. And corporations are also the ones who have the potential to help. With great power comes great responsibility. And we see the potential for corporate activity to be both the agent of harm, but also the agent of good. And here, let me be clear, I'm not talking about corporate social responsibility. Corporate social responsibility is an I want to do nice. Corporate social responsibility is not a balm to having destroyed an economy and then building a school, which, by the way, is just a structure, an empty one, much like the shelf company to which I referred earlier.
Professor Meyersfeld, your story is bleak. But I'm now hoping for the happy ending. What is the happy ending? Apart from the treaty that is being negotiated, are you aware of any other regulations that we could turn to hold the likes of the Kredietbank accountable? Or is that something of the future? Need we wait longer? What are your concluding remarks?
I think that there are international mechanisms. Whether or not they would be available to South Africa is questionable, simply because of the region in which they operate. I think we could look at some of the regional fora, such as the African Commission, but they would have no jurisdiction over a foreign bank. But let me tell you where I am hopeful. International law is not a fast-moving industry. It is a slow-moving industry. And if we look at corporate accountability, we can actually see by comparison that there has been a vast acceleration in principles of corporate accountability, even if it's in the discourse internationally. And bear in mind that human rights really only emerged as a body of law in 1945 after World War II. I'd like to just put a pin, though, in the problem that it emerged after 1945 and not in the 1800s after the formal end of slavery, which was never actually an issue that gave birth to human rights laws. It was 1945 and the Holocaust that did, which is not to say the Holocaust should not, but I do think we have to query why there has been a profound international response to the Holocaust and profound international silence to the 1800 slave trade, especially by the American government. Let me go back. 1945 is a very recent moment in the history of international law. And within that period, we've seen vast acceleration in respect of corporate accountability. And that vast acceleration has been the responsibility not only of states in the global south, but particularly of civil society. And I know we hear this a lot. Civil society is an important fourth estate. First your judiciary, then your swipe of executive, and of course our parliamentary lawmaking bodies. We are the fourth estate. And that is an agent that is as powerful as many governments. So the people sitting here, the media filming, the agents of this tribunal, the people who fund the tribunals, this is the fourth estate able to effect further change. And I don't think it's ever been as powerful. It's never been as powerful because of the ability to communicate in an instant, because of the very technology that we would one day want to fight against, we are also utilizing. And to continue in that progress and process, I think I'm very heartened by the development. We're far from the end, but we're very far from the beginning.
I have come to the end of my questions. Thank you. Now the panel is going to ask you some nice questions.
Thank you very much, Bonita, and thanks for that realistic but optimistic ending. Thank you very much. I just wanted to maybe for you to tell us more about the OECD National Contact Point system, and particularly the option of the statement, because you said that in addition to establishing whether there was a breach, there's the third component of that, which is compensation. What in examples, what was the nature of those compensation in cases? I know you mentioned the DRC, but I thought maybe you can tell us more about what has happened and what the nature of the compensation was.
Thank you, Honourable Member. I know. There was some hesitation that I began, but may I say it's an indication of the respect that I have for you doing this. My language may have been inappropriate. It was, compensation is something that can be a recommendation, but it's one of many forms of consequence. So there could be the recommendation of reparations, of an apology, of desisting with the activity. So what would we be looking for in a typical, in a potential, well, in the actual OECD complaint that we will be bringing within the next month or two? The request very much will look at some type of acknowledgement of accountability on the part of Kredietbank in busting sanctions and facilitating the oppression of the National Party during apartheid. The second, which is very much my hope, and I think the hope of all those involved in that National Contact Point request, is that there is a realization that we need an international regulatory body for banks, and that there is a recommendation from that national contact point that the states that hold themselves out as the paragons of corporate ethos, of ethics, of proper banking activity, such as Luxembourg, Belgium, such as certainly the United Kingdom, that those states undertake to develop both binding international standards vis-à-vis banks and human rights, and then international fora to ensure that those instruments are implemented. So I think the problem, we're facing two problems with the National Contact Point. The one is there is not going to be money in hand, I don't think, to any person who suffered during apartheid. Would I like to see that? But of course. Do I think it's realistic? I doubt it very much. To the extent that there is any ideal outcome here, it would be that, for example, Kredietbank goes, look, we're deeply sorry, which I'd be surprised if they did, we're deeply sorry, we were a very small bank at the time, we needed to make a lot of money, we've got a big name, we've got a big amount of money out of this, we're going to contribute to some kind of victims fund, right? That would have some kind of ameliorative purpose following the harm done by apartheid that is continuing in our country. Another option is, or another difficulty is that this activity happened a long time ago. Now, part of the problem I identified in answer to Advocate Muvangwa's question is that of retrospectivity. How do you hold an entity to account for harm that occurred a long time ago? And we are hoping that the NCP will look past that and will understand that because it isn't a formal judicial entity, that it will allow us to speak to this harm, and that Kredietbank will face its activity with integrity and an intent to ensure that that type of thing never happens again.
All right, thank you very much.
Thank you very much, Bonita. It's a great pleasure to see you again here. And of course, I can't argue with much of what Bonita has told us about the obstacles we face under international law. But as you said, we never had international criminal justice of 60 years after Nuremberg. And now, in a short while we have, wouldn't you say, because of civil society pressure. So that's why you say there's still hope of us getting there. And I also wanted to draw your attention to exposure, the power of exposure and peer pressure. Companies don't like to do business with each other if the one is exposed as corrupt. You gave us the DRC diamond dealing companies as an example. More recently would be Bell Pottinger and KPMG, right? So when there was exposure, there is a reaction from the companies themselves. I would like your opinion on whether it's worthwhile looking into codes of ethics, internal agreements that companies adopt, for instance, World Bank rules, or even amongst themselves at Davos and so on, where they commit to undertaking certain observing Ruggies rules and guidelines. So is it worth one's effort to look into what they undertook, see that, and bring up their violations, perhaps in courts of law?
Thank you. Yes, is the short answer. We need to pursue every mechanism available to us, and a healthy internal regulatory approach on the part of corporations and the banking industry is seminal. But it's not the ultimate answer. And why is this? Well, firstly, because the idea of a human right should not rest on the voluntary notion of a bank as to whether or not it wants to do this. And I know this is very much in keeping with your work in many of your mandates, including as the High Commissioner for Human Rights, that there is a fundamental notion that a person, a human being, should not experience a violation of their rights. I would add that that extends to non-human animals and to environmental principles. But for the moment where we are in international law, it seems to me incompatible that you can say to an entity, well, you can choose whether or not to commit a human rights violation. And the value of voluntary mechanisms is precisely, in my view, in the part that you've mentioned. It's peer pressure and it's exposure. That is precisely where the voluntary mechanisms come into play. It is a kind of race upwards as opposed to complete silence. There is another difficulty, I think, or another deficiency with voluntary mechanisms, is that it sometimes allows for compliance to occur in a contradictory but simultaneous way with non-compliance. So on the one hand, you can be imposing on you're going to be committing a certain level of human rights violations while simultaneously complying with one of the many principles or standards. We see this often with environmental standards. So environmental standards would say, for example, this is the extent of pollutants that may, according to our standards, be released into the air in a particular context. And a company may comply with that while simultaneously removing communities from land on which they've been settled for thousands of years or hundreds of years, in which they have a functioning agrarian economy, to another part of the land which is, of course, unsustainable. We might see, and I think we have this in the current context in South Africa, we might see a company responsible for grant distributions, for example, the distribution of social grants. That distribution provides an incredible fulfillment of the constitutional right to social grants. At the same time, though, that technology has been found to utilize personal data of grant recipients in a manner that has compromised their human rights to privacy. And I think that we can see the possible duality arising from internal voluntary mechanisms. But we dare not give up on them because they are the precursor. In fact, in my view, all of international standards are preceded by a commitment to values. And we saw that with our own constitution. It's preceded by a commitment to certain values. And we must transfer, or we must proceed from that which is voluntary to that which is compulsory in order to achieve the very objective we want. But I would never say we must abandon internal standards.
Member Yacoub, through you as the chair, I'm advised that Professor Meyersfeld has time constraints. I just wanted to bring that to the attention of the panel. She needs to leave 5 minutes ago.
My apologies for that.
In that case, I have no questions.
Well, actually, if I may take further liberties, Member Yacoub, if you do have questions, Professor
No, I don't.
Meyersfeld, she could answer them in writing.
I'd be happy to take a few more minutes as
No,
well.
no, no, no questions at all. I mean, I had no questions anyway.
Okay.
You, Mandisa?
Thank you very much.
Thank you for coming.